Deciding whether undisputed facts qualifies persecution under the law involves legal interpretation, not fact-finding. Even the BIA agrees. It treats the issue as a question of law subject to de novo review. That should not change when a case reaches federal court. Indeed, the government concedes that courts must exercise independent judgment when establishing auxiliary legal principles for use in future cases. They concede that courts owe no deference in interpreting the INA's persecution standard. And courts have repeatedly established auxiliary legal principles on things like sexual violence, religious persecution, economic deprivation, and beyond. But courts did not establish those principles by pondering the term persecution in the abstract. They interpreted the law by applying the persecution standard to particular sets of undisputed facts. The government wants you to hold that de novo review applies anytime a case supposedly would make new law in some sense, but substantial evidence review when it wouldn't. There's no principled way to draw that line, and this court has never tried in similar circumstances. For instance, de novo review applies to all fair use determinations made on undisputed facts and all antitrust determinations made on undisputed facts, not just some special subset. The government's contrary rule here would invite further confusion and collateral litigation. Better instead to just require de novo review and let judges get to judging. The courts of appeals are well equipped for the job. Several of them already have experience reviewing de novo the BIA's persecution determinations, and they generally review the analogous question whether undisputed facts demonstrate torture under the Convention Against Torture. The sky has not fallen. Under both the INA's text and U.S. Bank, courts should decide for themselves whether undisputed facts establish persecution under the law. Section 1252B explicitly provides for legal deference on closely related issues, but not this one. And decades of experience confirms that courts perform crucial legal work in applying the INA's persecution standard. Deference to the BIA is unwarranted. I welcome the court's questions.
Urias-Zacharias was also a persecution case, and that was reviewed deferentially. How is this different?
Because Urias-Zacharias concerned a different element of the asylum eligibility analysis. The Urias-Zacharias, the disputed issue there was about the persecutor's subjective motive, their intent. That is a classic pure question of fact, and so Urias-Zacharias was absolutely right to review that factual determination for substantial evidence. The statute before the court in Urias-Zacharias, which was the predecessor to Section 1252, B4, also, it didn't say the asylum eligibility determination across the board. It applied only to findings of fact, and that's what this statute says as well. So we think the government is just overreading that decision.